Ladies and gentlemen, welcome to the Civil Justice Committee. Melinda, would you, let's see, the clerk calls the roll. Ma'am, would you call the roll for us, please?
Representatives Bricken, Clemens, Curcio, Eldridge, Farmer, Garrett, Gillespie, Griffey, Harris, Littleton, Ogles, Parkinson, Ramsey, Smith, Stewart, Vice Chairman Jernigan, Chairman Carter.
Here.
Mr. Chairman, you have a quorum.
Thank you. Are there any personal matters we need to take up before we start with the calendar? Any personal notes? All right. Ladies and gentlemen, item number 1 on our calendar, House Bill 765 by Leader Lambert. We've been asked to roll that. They're in another committee. They'll be here very shortly. So let's just roll it 3 spaces, and I assume we'll just get back to it at a time that doesn't offend anyone as quick as possible. What about item number 2? Did he want to roll it too? Okay, Representative Gillespie. Okay, House Bill 783 by Representative Gillespie. We've got a motion and a second. You're ready to be heard. You're recognized.
Thank you, Mr. Chairman. Just 1 second. I'm sorry about that.
No. Take your time. We're in no hurry. Just relax. It's your first bill?
No, sir.
Oh, shoot. Second. Shucks. Okay. While Representative Gillespie is preparing, getting his notes together, Callan Schmidt of the Governor's Office is here to answer any difficult questions or specific questions if anyone has them. So you're well versed, Representative Gillespie.
Thank you. All right. So this is a bill that basically has been required the juvenile court clerk and the Department of Mental Health and Substance Abuse to provide certain data to the Administrative Office of the Courts each month. And it's basically just making that conversation between those two entities and the data that's resulting from it a little bit easier to share, and kind of gets rid of some of the unneeded data that's currently being shared, I guess, is the basic substance of the
All right, sir.
bill. So,
We've got a motion, a second. Do we have any questions? All right, hearing none, the question on the bill has been called. Are we ready to vote? Seeing no objection with the question being called, all in favor say aye. Aye. Any opposed? There are none opposed. Bill passes to calendar and rules. Good job, Mr. Gillespie. Yes, sir.
Mr. Chair, I couldn't let my delegation member just get by with his first bill without me saying something, so.
Well,
Just wanted to say.
I fell in the same trap. It's his second bill.
Oh, it's the second bill, okay, all right.
Yeah.
But he hadn't been to the well in the chamber yet, had he? No, okay. So, Mr. Chairman, as far as we're concerned, still his first bill then, right?
All right. Well,
Thank you, Mr. Chair.
all right. Representative Ogles, you're recognized.
Thank you, Chairman, and to the sponsor. I hope the next bill you actually read before you come to committee, and that will be your first bill. Thank you.
Said with a smile and much love. All right. The next bill, item 3, is that one we can go ahead and hear now, too? Yeah, House Bill 1096. Representative Baum is tied up. He's going to need to roll that about 3 spots. So let's go to item 4 is House Bill 1048 by Representative Sherrill, and it is, excuse me just a minute, it's been taken off notice. That brings us back to item 1, and Representative Garrett, are you going to handle that for us?
Yes, Mr. Chairman.
All right. Did you say Madam Chairman?
I did.
Yeah, I thought so. Also,
Mr. Chairman, I am going to handle that.
I've been accused of a lot worse, so. Representative Garrett, you're recognized.
Thank you. This is an administration bill for the Department of Human Services, and it deals with the child support guidelines. And I practice in this area quite often, and sometimes our guidelines are changed and actually become practice, but it takes a little while for the code to catch up. And so that's what these are doing, and we are updating our child support codes to reflect actual practice and what's happening according to the child support guidelines. So with that, Mr. Chairman, I'll be happy to take any questions.
All right, thank you. We were having a little friendly banter at the beginning. Did we have a motion and a second? Did I miss it? Okay, we have a motion and a second. Are there any questions of Mr. Garrett? Representative Garrett, you're recognized, Representative Parkinson.
Thank you, Mr. Chair, and thank you, Chairman Garrett. Can you just give us is it like an entire encyclopedia list of those changes, or?
Representative Garrett, you're recognized.
It's not an entire encyclopedia, but there are some changes. For instance, if you want to change child support under our code, it's a 7.5% variance between what that would be based upon the party's incomes. In practice, none of the guidelines, it's actually 15%. And that's what practicing attorneys are doing. And so we're just sort of updating things like that. So
Representative Parkinson, you're
Thank
recognized.
you, Mr. Chair, and thank you, Chairman Garrett, on the explanation. I remember now because I was giving DHS a hard time about this, telling them I was going to be deferred, but I'm actually going to support the bill. So thank you, Mr. Chair.
thank
Other
you.
questions? No other questions? The question's been called. All in favor, say aye.
Aye.
Any opposed? There are none. Bill passes to calendar and rules.
Thank you, Mr. Chairman and committee.
Thank you. I think I saw Representative Baum come in. Let's go back to number 3 on your calendar, House Bill 1096. Representative Baum, you're recognized. You have a motion and a second.
Thank you, Chairman Carter. One issue that we're dealing with in our schools is student discipline. This is a problem that's probably being made worse by mental health issues and substance abuse. Some have concerns that teachers are letting student conduct go out of a fear of legal liability. In Tennessee's School Discipline Act, principals, teachers, school employees, and bus drivers already have the authority are already authorized to use reasonable force in order to correct or restrain students so that they don't hurt themselves or other students. And when exercising this authority, these individuals already have criminal immunity. But there's nothing in the code that gives them civil immunity. That's what this bill would do. It would provide these teachers civil immunity when they're exercising the provisions of the School Discipline Act. Nothing about this bill would authorize corporal punishment, and the conduct would only provide immunity if the teachers are not grossly negligent, reckless, or guilty of intentional misconduct. I think this is a bill that would signal our support of teachers as we recognize some of the issues that they face.
All right, let's see. I had Representative, we've got so many. Jernigan first. Representative Jernigan,
Okay.
you're recognized.
The quick question that I have is, would the family of the student still be able to sue the school system?
That's a question I received before, whether the LEAs would be liable. Nothing in this bill would address the LEAs to the extent that they're responsible for their employees. Nothing would affect that, other than the bill does say that the teacher or student or school employee could not be the proximate cause of some kind of an injury or approximate cause of liability.
Okay. I just don't want to get into a scenario where I have a 10-year-old gets restrained and inadvertently breaks his neck, and then I can't sue him civilly or the school system. It's a very expensive life to live, but I think from what you're saying, it sounds like that the school system nothing changes from what you can do now with the school system and being able to sue them. Is that accurate?
That's correct, and I probably should say that the civil immunity would only be provided for the teachers if they're using reasonable actions, reasonable force in order to enforce conduct, and again, that reasonable force could not be characterized as gross negligence, recklessness, or intentional misconduct.
Mr. Chairman?
Yeah,
One
thank you.
more follow-up. Yeah.
You're
So-
recognized.
And Sometimes I have concern about the word reasonable being subjective, but I think I understand where you're coming from. Thank you.
Representative Clemens, I've got you next.
Thank you, Mr. Chairman. And to follow up on that, and Representative Jernigan was asking a question about that I touched on in the subcommittee. And under the Government Tort Liability Act, an LEA would still be liable for the negligent conduct of a teacher. And that's not being addressed by this bill. Though I think this bill's perhaps unintended consequence is that it could push more liability on LEAs because teachers may feel more emboldened to push the envelope, so to speak, therefore creating more liability for their LEA rather than being careful to a negligence standard. So in that regard, you know, what you're doing here, and correct me if I'm wrong, you're elevating the burden of proof from a reasonableness standard, how a reasonable person would act under the same or similar circumstances. That's negligence. You're raising that to gross negligence or recklessness, correct?
I'm not sure about this. The provisions about using reasonable force are already in the School Discipline Act, and this bill doesn't change that definition or that language in the code. All this bill says is that if the teachers or other school employees are exercising their authority under existing statutes, under the School Discipline Act as it's already written, that they're civilly immune.
Mr.
Representative Clemens, you're recognized.
Thank you, Mr. Chairman. So, but what you're doing is you're creating this immunity unless they act recklessly, grossly negligent, or otherwise. That's elevating that burden of proof.
Those are
De facto.
Those are the circumstances under which the civil immunity would not apply.
Right. So they would have to act recklessly, grossly negligent. So that's the burden of proof. You're going to have to prove to have a case against the teacher.
Yes, although I should say that we added those terms, essentially that sentence in the bill, in order to make it clear that there is a difference between exercising the authority that's already in the statutes and going beyond that. It was a sentence that was added not to necessarily elevate the standard, but to make it clear that the civil immunity has limits.
Okay, one more.
You're recognized.
Thank you, Mr. Chairman. So since that's the exception, let me give you a hypothetical. If a teacher or teachers drag a student down the hallway by their feet, is that negligence or is that gross negligence, in your opinion?
That's for the courts to decide.
Well, that's what I'm trying to gauge. What is the type of conduct that you're seeking to create immunity for? So is that, I mean, what, your bill, I mean, you have an intent for the legislation, so what type of conduct are you wanting teachers to be able to do versus what you don't want them to do?
Right, and I do understand the question, but I'm not in a position in order to make that determination. That's a decision for the courts to make. But if it's deemed not to be grossly negligent, to where the teachers are simply enforcing the provisions of the School Discipline Act as they're already written, they would be civilly immune.
So you don't have any opinion on that hypothetical situation, whether that would constitute gross negligence or recklessness versus regular negligence?
Without hearing the other facts in the case, I'm not prepared to issue that kind of an opinion myself. I'm not trying to be the court in this case. I know of a real world situation where that arose and it was considered to be involved negligence, but I would hate to make some kind of a statement regarding the specific circumstances that you're referencing that would somehow bind court decisions. It would be for the courts to decide.
Okay, I mean, thank you. I don't think anything you say here today is going to bind any court, but I understand your position. Thank you, Mr. Chairman.
You're welcome. Representative Stewart, I have you next.
Thank you, Mr. Chairman. Could you explain a little more about the final sentence in this paragraph? A person who is immune in this section is not the proximate cause of any resulting injuries. Here's my confusion. Okay, I don't know of another statute, but they may exist where we establish causation in this way. So if a person X commits an act and they're deemed immune, then that person can't be identified as in the as the cause of the event? Is that how that works?
The
The
intent of
injury, if you will?
the intent of this last sentence addressing the proximate cause of injuries would work like this. Let's say that there's a fight between two students, and a teacher intervenes to break up the fight. And in this fight, one of the students is injured. The teacher may be immune, or would be immune, due to the provisions of this bill. If one of the students sued the other student for an injury, they wouldn't be able to use as a defense that the teacher somehow caused the injury by intervening in the fight. In other words, the teacher couldn't be the proximate cause of a resulting injury.
Yeah, I guess my question, though, is if a teacher is working for a school system and under the school system's policies acts in the teacher's minds and the eyes, we'll just take for argument's sake acts reasonably because of improper policies, improper direction, other problems created not by the teacher, okay? I liken it to a soldier under the command of the wrong person can do very bad things even though it's not the soldier's fault. To me, if you break the chain of causation with the teacher, aren't you potentially creating a situation, because the teacher is still the person who actually inflicted the harm, or the bus driver, or what have you, aren't you creating a situation for the person in court, makes it very difficult for them to prove causation in any way? It seems to me you're breaking a causal chain in a way that we don't normally do with statutes. I think you should consider looking at that more carefully, because that's an unusual phrase to place in a statute, and I think it's going to do mischief as a practical matter when it comes to these sorts of cases. What do you think about that?
If I understand your question correctly, you're suggesting that there's an improper policy, and the teacher's enforcing that policy. This bill provides the teacher civil immunity if they're enforcing the provisions under the School Discipline Act reasonably. You're wondering if somehow liability can be placed on the teacher because of the improper policy?
No, I'm saying that you have a person, to take Chairman Jernigan's example. We have a child now with a broken neck. Because that's what we're talking about. These lawsuits can involve very serious matters, people's children severely injured, and the question is, are they going to be impoverished because we passed this bill, or are they going to have an opportunity to get a recovery? Opportunity, obviously. It may be that for any number of reasons they don't get a recovery. If we take the teacher out of the chain of causation, won't we make it potentially very difficult for them to prove their case, even if there may be some negligence or bad behavior on some other actor? I mean, if the teacher is the one who actually pushed the child, grabbed the child, whatever it is that's the injury-causing event, if you take them out of the chain of causation, how are they going to prove causation?
It seems to me like in the hypothetical situation you're describing that the problem would be with the school policy, not necessarily the teacher.
I think that's exactly my point. And the problem is, though, to establish a negligence case in Tennessee, you have to prove duty, breach, cause, and harm. To establish most liability in this state, you have to establish a chain of causation. It seems to me this statute would really work mischief. Not the rest of it, and I understand it's very well intended, but this last sentence here, it seems to me, potentially makes a real difficult situation for a court because it'll break the chain of causation. I think you should consider changing that last sentence because I don't think we typically do this. I think that the causation is left to the court. You're establishing your immunity. I'd leave it at that.
Representative Parkinson, I have you next.
Thank you, Mr. Chair, and thank you, sponsor, for I understand, what you're trying to do and where you're going. And I just want to kind of piggyback along the same lines as Representative Stewart. So based on that, you know, let's use this scenario. If a fight breaks out and it's kind of a push and shove event, right? And a teacher comes in and in order to break it up, they push the students apart. One of the students falls into a locker and breaks their neck or receives an injury. Then based on that last line, where there was no injury, then now there is an injury. That person that pushed the student that caused the injury would receive immunity?
My understanding of the way the bill is written is that if the teacher were deemed to have used reasonable force necessary to break up the fight, then there would be no liability, no civil liability. But if the teacher went beyond reasonable force in order to break up the fight, then the immunity would not apply.
Completely understood. You okay with me?
Yeah.
Mr. Chair? Completely understood. But I would assume that pushing the students apart is reasonable force to break up a fight. And one happens to fall and, you know, hit his head in an open locker and injures his head or breaks his neck. But because that teacher used reasonable force under this legislation, based on that line, they would not be liable, you know, for that child's injury. That child, if it was just a push and shove event, you know, that looked like it's going to be a fight, and you run over there and you stop it and push them apart, and one gets injured, based on that last line, that teacher would not be responsible for, you know, that injury. Is that your intent?
If the teacher has used reasonable force as defined under the statutes, then they would not be civilly liable. And so if it's deemed that pushing was necessary to break up the fight, someone gets injured, the teacher wouldn't have liability. Excuse me, doesn't mean that that there wouldn't have been an injury, the teacher just wouldn't have been liable because their behavior would have been in accordance with the School Discipline Act.
Okay. And under the School Discipline Act, does it expressly explain what is reasonable and what is not?
The School Discipline Act is in Part 41 of the code, and it's already a fairly lengthy section. Part D that you're seeing, well, this would add a Section 2 to that act, defining or outlining the civil immunity.
And Mr. Sponsor, and I'll give you my word, I'm not trying to trip you up on this. I'm just trying to get a little bit more clarity on it. And Mr. Chair, if we can.
You're recognized if you want.
I saw legal moving their iPad over, because I was about to ask, can we go to legal just to get clarity on what that definition of negligence or acceptable practice is under the School Discipline Act, just so I can get more clarity about what, you know. Is that okay, Mr. Chair?
Yeah,
Thank you, sir. And Mr. Sponsor.
All right, let's allow legal to respond if possible.
Yes, sir.
Michelle Fogarty, Office of Legal Services. Under 49.6.4107, a teacher, principal, school employee, or school bus driver, in exercising their lawful authority, may use reasonable force when necessary under the circumstances to correct or restrain a student or prevent bodily harm or death to another person. This section does not authorize use of corporal punishment by a person not permitted to administer corporal punishment, and it does not authorize restraint or isolation of students for whom restraint or isolation is prohibited under Chapter 10, Part 13 of this title. I can search this section and see if there's a definition of reasonable force, and I'm not seeing that that's defined, but I will search one more time. Hold on. Usually reasonable force is a jury question.
Okay. Whenever you're ready. Yeah, let's look at it. Okay, yes.
And I'm not seeing a definition of reasonable force for
All right.
this section.
Back in session.
I'm sorry, Mr. Chair, I had another question for legal before we came out of recess, if that's okay.
All right, go ahead.
Okay. Thank you, Mr. Chair. If you can you give us the difference between negligence and gross negligence?
I'm looking to see if it's specifically defined in our code. There's not a definition in our statute of gross negligence. So that would be, then you would look to case law.
Anything else?
No, sir, on the bill.
All right, back on the bill.
And thank you, Mr. Chair, and thank you to our legal team.
Back in session.
Okay, yes, sir. So under the definition that legal read to us on reasonable force, it said the last part of that was to prevent injury, And under this legislation, if an injury is created using reasonable force, they would receive immunity. And and I don't know if this legislation is going to supersede the previous definition of what legal read to us. So if reasonable force under the definition in the law is to be used, but used to prevent injury, and an injury is caused, then we are now creating a conflict in Tennessee code that would give individuals immunity for using reasonable force that was actually defined to prevent injury. And so I think just something to think about, and maybe we can consider some adjustment. Also, the last thing, I had in my notes to understand the difference between negligence and gross negligence, and it's not defined in our code what gross negligence is. But I would ask, why we're removing negligence from that and giving immunity when people are just negligent in their use of force and with our children. So do you mind answering that?
Okay, you've raised several issues. I guess a couple I can comment. On, even though reasonable force isn't defined in this section, there are a couple of things that are identified that are excluded from reasonable force. First of all, corporal punishment is not authorized by this section, and there is a part of the section that says that the school employees may not restrain or isolate students for whom restraint or isolation is prohibited in other parts of the code. Okay. So there are a couple of things that are precluded by this section. You also referenced gross negligence versus negligence. The Tennessee Trial Attorneys Association helped us with some of this language. Their recommendation was to include the phrase that uses gross negligence. The phrase is actually gross negligent, reckless, or intentional misconduct.
Right, understood. But so reasonable force is not defined there, but it is defined in the code. And under that definition that was just read to us, it is also in that definition it said to prevent injury. And so it appears to be a conflict in the language of the legislation versus what's in the code. If the code says reasonable force is used to prevent injury and an injury occurs, then no one is responsible for the violation of the law based on what the definition of reasonable force is. So if I was to get into the middle of two students fighting, and I need to use force to prevent injury by the law based on what the definition of reasonable injury is in the code, under your bill, I would be, if I injured those students, I would be in violation of the law. Wait, without your bill right now, I would be in violation of the law. If I use reasonable force, and under the definition of reasonable force is to prevent injury, and I injured someone, then I'm violating what the definition of reasonable force is in the code right now.
I don't think this bill introduces a conflict, because I can imagine lots of situations in schools where two students are involved in a conflict, where they're in the process of injuring each other, or maybe one killing the other. In those situations, the teacher is authorized to use reasonable force to prevent that from happening. And I can see in the process of preventing two students from trying to kill one another, one of them gets pushed back or might incur a slight injury. The current statutes authorize principals, teachers, school employees to use this force in order to prevent bodily harm or death to another person. So in order to prevent these things from occurring, reasonable force is authorized. I can imagine lots of situations where in order to prevent bodily harm or death to another person, a teacher uses force that would result in some type of lesser injury.
Okay. Thank you, Mr. Chair. Thank you, Mr. Sponsor.
Thank you, Mr. Chairman. If I may, for the committee members, and this is from my good buddy John Day's website. He's probably one of the best trial lawyers, plaintiffs' lawyers in the state of Tennessee, discussing negligence versus gross negligence. And this is from the Colby Woods case, 584 Southwest 2nd, 640, Tennessee Supreme Court, 1977. And they're talking about what constitutes gross negligence. And they say that the actions do not constitute gross negligence in that they do not evidence such entire want of care as would raise a presumption of conscious indifference to the consequences, or a heedless and reckless disregard for another's rights, or utter unconcern for the safety of others. And to the sponsor, I appreciate this legislation and the questions of whether something's going to be reasonable, unreasonable, negligence, gross negligence. Those are all questions for the jury. This legislation does nothing to do that, tilt that balance. But what this does do, this will filter out some of the nuisance harassment cases. Because I think, in my experience, we've seen a number of our school districts get sued by attorneys that know that the school districts have insurance. They can pay the fees. And so if there's a dispute, breaking up a fight or somebody can always claim, I hurt my shoulder in that. The teacher grabbed my leg. Now my leg's hurt. You know, soft tissue injuries. Those are extremely difficult to prove one way or another. And so the plaintiff's lawyers can sue the school district. And it's a lot of times it's easier and cheaper to settle the stuff than it is to take it to a jury trial. And who ends up paying that cost is all of us. The taxpayers end up paying those costs when we see abuses in the litigation like that. So this is smart litigation. This is, smart legislation. It is making a standard. If a teacher is trying to use reasonable care in enforcing discipline or breaking up a fight, if someone happens to get injured in that, that's not the teacher's fault. They were simply trying to do what they're supposed to do and trying to act reasonable and not grossly negligent. Now, if a teacher's breaking up a fight and they grab a desk and they throw it on both of the students involved in the fight and injures one of them, that's probably going to be gross negligence. So I think this is smart. I appreciate you bringing the legislation. I'm happy to co-sponsor it. Thank you very much, Mr. Chairman.
Next, have Representative Garrett.
Thank you, Mr. Chairman. Chairman Baum, thank you for bringing this legislation. I want to kind of comment on a couple of things. The reason why I think this bill is important and the reason why I think you've done a good job explaining it. But let me we get caught up in hypotheticals that tend to be extreme. And I agree with Representative Griffey that the facts of the case are just that, they're facts. And the person that gets to decide those facts is the judge and the jury. Simple as that. We can come up with all kinds of scenarios that says this and this, what happens this and this, and it doesn't make a lot of sense when this bill. But what it does do is that I think of this as a business. A lot of us have businesses outside this General Assembly. We have a limited liability company. That limited liability company protects its owner from that owner's personal liability on the obligations of that business. To pierce that corporate veil, it's very difficult to do. That bar is very high. What's the difference in a teacher that works for a school board? That teacher's an employee, they work for a business. They act in a way that could be reasonable. Well, what's going to happen? This teacher's going to be sued, because in lawsuits, I tell people every single day, anybody and everybody can be sued for anything, unfortunately. That's the way that it is. What does that teacher have to do? Hire a lawyer, defend it, potentially go bankrupt, because they acted reasonably under a current law. That does not happen in business, because we have that personal liability protection, because we create an LLC that creates a higher bar in order to get someone personally under a corporation. That same standard should apply to our teachers when they act reasonably. Does that what your bill intend to do?
Yes.
Thank you very much for bringing this. I'm going to be glad to vote for it. Thank you. I hope our teachers don't go bankrupt defending lawsuits.
Thank you, Representative. I have Representative Ogles next.
Question on the bill.
All right, question's been called. Is there any objection? We had Representative Littleton left to speak. Any objection? No objection. All right, the question's been called. All in favor of the bill, say yes. Yes. All opposed, say no. No. Yeah, the ayes have it. Passes to Calhoun rules.
Thank you all.
Number 4 has, we've already taken that off notice. Where are we back to now? I see.
Let's go out of order and take up item 6.
We've got Rusty Grills here.
Yeah, that's item 6.
Okay. All right, let's go out of order. I see Representative Grills here. Let's take him while he's ready, if we can. Item 6, House Bill 0059. Representative Grills, you're recognized. You have a motion and a second. You're ready to proceed. You're recognized.
Thank you, Mr. Chairman and committee. Ultimately, what this bill does is removes the bond on the civil asset forfeiture. That's it. That's it. Ms. Stroker here with the Department of Safety. She and I have talked about this several times, and the department is okay with it. And this bill was passed last year, made it all the way to the floor and passed the floor, I believe, and then the Senate. I don't believe the Senate finished their job, but anyhow.
Question on the bill. Question's been called. The department last year was very vocal on this in support of it. Do they want to speak this year? They cleared the permission to speak. If they want to, I'll allow it. And if not, we'll just go forward. But recognize that they do agree with the bill, unless something's changed since I last spoke with them.
If we have the votes to pass it, let's don't.
All right, the question's been called. All in favor, say aye. All opposed, say no. Bill passes to Calhoun rule.
Thank you.
Oh, wait a minute, excuse me. You got to go to finance sub. I'm sorry.
Thank you, Mr. Chairman. Good to see you in committee. Anybody want to sign on, please holler at me.
All right. Item 7, if you turn to item 7, Representative Lamar. You have a motion and a second. That's House Bill 0340. Representative Lamar, you recognize we have an amendment. And that amendment number is 0378.
Yes.
I'm sorry, 3678. We have a motion and a second, I believe. Any objection to adding that amendment? All in favor of adding the amendment, say aye. Any opposed? Amendment's added. So we're on the bill as amended with 3678. You're ready, Ms. Lamar.
Thank you. What my bill does is require that audio-visual recording be made of any interrogation of a juvenile who's been taken into custody on suspicion that the child committed a delinquent act or unruly conduct. This recording can be used either through video or audio. And law enforcement with reasonable good faith can not use this step in extrinsic circumstances only.
Questions? I'm sorry. Yeah, Representative Bricken, you're recognized.
Thank you, Mr. Chairman. I'm trying to get an understanding of the bill. Is this delinquent and unruly applies in a school environment or any environment?
If they're taken into custody by law enforcement. So anyone considered law enforcement.
Well, it doesn't say.
Okay. Then why, Mr. Chairman?
Yes, you're recognized.
Why is it
Representative
limited or to a delinquent or unruly conduct? I mean, I mean, if I see a child committing a crime, is that does that come under delinquent and unruly or not?
From my understanding, yes, but I will refer to legal just for clarification if needed, but yes. If they're taken into custody and you're interrogating them, this rule applies. So if they're taken into custody by law enforcement and they're interrogating them, they have to use either video or audio recording.
But
You're
then
recognized.
Why doesn't it just stop at taken into custody? Why does it even have the other language?
Well, I'm gonna ask our attorneys and legal why they put that, but I think that may be just a word issue versus the bill is any juvenile who's taken into custody. And you're interrogating them, you have to use audio or visual recordings.
Okay.
Well, I refer to legal.
All right, let's go out of session. We'll recognize Michelle.
Michelle Fogarty, Legal Services. In the juvenile justice system, when a juvenile commits an offense, it's called a delinquent act, or an unruly conduct would be like running away from home, not going to school. In the juvenile court system, you have delinquent acts and unruly conduct as opposed to criminal offenses. It's just a terminology used in juvenile court.
Other questions? Okay. Other questions for legal? All right, back in session. See, I thought we had Representative Ogles next.
Thank you, Chairman, to the sponsor. I just want to be sure for the record that the exemption for technical issues is not pushing stop on a recorder or not providing some mechanism to actually record that testimony. Thank you, sponsor.
All right,
Thank you.
Representative Garrett.
Thank you, Mr. Chairman. And Representative Law, thank you we discussed briefly this bill the other day on the floor. And I got a couple of concerns. One of those, and I don't do criminal work, so I hope you can maybe help me out here. I'm worried about the child's ability to assert its Fifth Amendment rights where I guess my point is, where are their parents? They're being detained by law enforcement. They're going to be then recorded. This recording could be used against them later in any proceeding. Are they Mirandaized? Is it anything going on while they are being recorded without their permission or their parents' permission? I've got real concerns that this bill doesn't address any of that. Can you kind of enlighten me on why this bill would be doing this?
That's a great point, and I share your concerns. My intent is to just focus on the interrogation part, but I will refer to legal again and ask the question of, before interrogation legally, does the parent have to be involved? If that's okay with the chairman, can I ask legal?
Anyone object? All right, out of session. Michelle?
I'm looking that up. I'll have to look that up as to whether or not
Go
a
ahead.
parent is required to be present when they interview a juvenile. So it'll
Well,
take me a few minutes.
Yeah, I don't think that's his question. The question is, this seems, in my mind, to give permission to take a statement without a parent so long as you record it.
That's exactly my concern.
And that's exactly what it says.
If regardless if the parent are present or not, it has to be recorded via audio or visual recording. Now,
I'm just saying that some lawyer's going to say that the parent has lost a right here. It's very concerning to me because the parent has got the right to control this completely under our current statute. And it seems to me that we're amending the parent out of that process. Now, if the statute said if the parent allowed for a statement to be given, it must be.
I will entertain questions.
Well, we're allowing legal, we're not just having a good time. Legal's doing their research. May I go ahead? Anybody object to hearing from Representative Stewart? Oh, okay, I'm sorry. I'll get Representative Stewart. I called you out of order, but go ahead and we'll come back to you.
Oh, thank you.
Out of session. We're just waiting for legal to catch up.
On this point, I don't watching the sponsor, it doesn't sound like you care. I mean, you wouldn't mind an amendment just fixing that issue, because it seems like the intent is consistent with what Chairman Carter's saying. Is that
Absolutely, I
right?
have no problem with that.
Well,
Could we just craft an amendment right now?
no, well, we don't do that under our rules. We can roll it a week and put an amendment under it, because this is certainly going to not be less than a technical amendment. But I'm very concerned about the way this is worded. I'm also concerned about what if a school well, not because they're technically officers. What if some person at school wants to take a statement? Are they covered by this? Who buys that equipment? What's the cost of all that? I've just got a lot of questions about this. I don't want a child to get whipsawed by this. Have you found your? All right, let's go back and recognize Michelle.
Michelle Fogarty, right now, it looks like that law enforcement can't interview a child without the parent's permission and consent
Anyway,
at this time. Yes.
Mr. Chairman.
All right, we ready? Let's go back in session. All right, we've got a bunch of people. Okay, I'm sorry, I'll come back to you. Representative Griffey?
Thank you, Mr. Chairman. To the sponsor, I appreciate you bringing this legislation, and it always, I've practiced both sides, prosecution, defense work, and I've always troubled me that with the technology we have today, that getting the actual recording of what statements were said on the record in a recorded manner for later presentation to the trier of fact or the judge, it's just extremely helpful. There's no disputing what was said, because people can misinterpret statements, write things down in shorthand versions, and sometimes the actual meaning of the words can get lost. But I wonder, have you talked with law enforcement about this bill, and the many of our local, more rural law enforcement counties, are they prepared to be able to provide this if someone's questioned? So, thank you, Mr. Chairman.
thank you, Mr. Chairman, and that's a great point. Yes, the amendments that I put on the bill and the corrections were made by the Police Association and suggestions of TBI. So yes, I have ran this bill by both organizations, and they were okay with it.
Does that include the Tennessee Sheriff's Association?
Is that Maggie?
I'm getting the signal it does, and with, Mr. May I? Thank you very much, Mr. Chairman, and thanks, sponsor, for that. With those assurances, then I'm going to support this legislation. I think it's smart, and it's again, it's always helpful to the trier of fact and the judge if we have a recorded rendition of what statements were made, because that is evidence that can be used against a person. So it's critically important to know exactly what was said, and I think it helps getting to the truth. And so I'm going to support your legislation based on that. Thank you.
All right, Representative Lamar? Yes, you're recognized.
Thank you, Mr. Chairman. Thank you, Representative Griffey. I agree. The intent is to bring transparency and integrity for both sides, both the prosecution and those who are defending themselves. If it's recorded, audio, and visual, you can't misinterpret. Any information is there, and with our most vulnerable populations, such as our juveniles, we want to make sure the information is clear and concise and as truthful as possible. So this is just trying to bring more integrity to the process. And with the clarification that the parents already have to be present, then you have to approve before you can start doing this interrogation anyway. So with that clarification from legal. So it does bring integrity, and it does bring transparency to the process.
Representative Farmer, you're recognized.
And I'm just trying to let this soak in, this conversation we're having, but it was my understanding that this is your intent, that there's not a situation where a minor is in custody by law enforcement to where they give a statement that's not recorded by audio or video, right?
Say that one more time.
So if I understand your intent correctly, you're trying to prevent a situation where a minor is in custody of law enforcement anywhere, to where they're going to give a statement to the officer, law enforcement, that is not being recorded by audio or video.
Right. Yes,
You just want to provide an extra layer of protection for those minors.
absolutely.
Now, if their parents are there, that's a different story.
That with their parents are there, it got to be recorded. And if they say no, it's a no. But if they agree to it, yes. If the parent says no, the parent supersedes. But if the parent is okay with it, because they have control, if they allow it, yes.
If I may, Mr. Chairman?
Sure.
So, number one, if the minor is unaccompanied by a parent and they're in custody, and if they make a statement, that statement's got to be recorded, no matter what.
Right.
Scenario two, if that minor's with a parent, the fallback is that statement is going to be recorded unless the parent says, we don't need it to be recorded.
Perfect.
Correct?
Yes.
Is that what you're trying to do?
Yes, sir.
Okay, thank you.
Representative Garrett.
Thank you, Chairman Farmer, for that, but let me just make sure that I understood that, make sure that I understood your intent. Okay, I don't mean to
No, you're
beat a
fine.
dead horse here. But I believe what Chairman Farmer was saying, and make sure I understand it, is that when the parents are unable to consent to protect the minor, you were telling law enforcement, you cannot interrogate this person if you're not going to record it because their parents aren't there. Is that the intent of this bill?
Yes.
Okay. Okay. Thank you very much. I appreciate that explanation. All right.
Representative Ogles, you're recognized.
Thank you, Chairman. To the sponsor, I think we've created some confusion, at least I'm confused a little bit about the process of Miranda and when that's administered, and if in fact that child, just since we're running scenarios, where is the advocate for the child, even if the parent comes in and says, you're going to tell the truth, you're going to tell them what happens right now, or you're going to, I'm going to spank your butt when you get home. And that child starts, is that child at any time given an advocate to say, well, wait a minute, you don't need to necessarily self-incriminate. You don't need to, because anybody that has any legal training or any capacity to protect their child would say, we're not going to make a statement until we get representation. There's some very slippery slope there, I believe. And, excuse me.
Could I interrupt you just a minute? Legal has an answer for that. I'd like to hear from them if we can. Legal?
Michelle Fogarty, Legal Services. The juvenile has the same rights as an adult taken into custody. They have the right to an attorney. They have the right to Miranda. And they have the right to only give a voluntary statement. So they have the same rights that an adult would have when they are in custody.
Chairman, if I may.
Yes.
But how have we allowed a child that cannot enter into a contract, who cannot buy cigarettes, who cannot buy alcohol, to waive their rights to self-incriminate when they don't have the mental capacity, the education, the training, or any experience to have that capacity to do that? I think we're kind of stepping into some areas that may need to be addressed. Thank you, Chairman. That's all I have.
Michelle, would you like to answer that?
I would believe those would be factors considered by the court when considering whether or not to admit the statement as evidence in the trial.
Might be a coerced statement if the parent was threatening the child. All right, let's see where we are now. We're back in session. Mike, I had you. And
I'm good, thank you.
Okay, all right. All right. Representative Griffey, you're recognized.
Thank you, Mr. Chairman. We're back in session.
Yes, we are.
And just briefly, if the law enforcement fails to record the statement, then statements that are attributed to the child that were made, they will not be admissible against the child in regard to the juvenile court proceedings. Is that your understanding? They'll be excluded?
That's kind of getting, yes, I don't want to try to cloud the conversations because I'm dealing with kind of one specific issue, but yes, that's my understanding, but I don't want to talk too much on too many things because this bill deals with one thing and, I don't want to act as if my bill is addressing some other issues, but I'm sure it's brought to the forefront some other things I think that as a legislature, we could work on together.
Folks, all right. Representative Clements, you recognize?
Thank you, Mr. Chairman. I think the concerns of the committee are warranted based on the literal language of the statute and as it reads with the other provisions of the statute. And I'd leave this up to the sponsor and the will of the committee. I think there could be a contingency clause inserted into this if an amendment was warranted, if this was held over for a week, but that's up to the sponsor. That said, if a statement is taken, then it shall be recorded, or something along those lines to really simply address the literal language of this. But again, I defer to the sponsor of the bill and the will of the committee.
All right. If I may stick my nose in this discussion at some point, Representative Griffey just said that these are juvenile court matters. I don't see juvenile court listed in this. So what if it's a 15-year-old and the officer pulls up and the guy said, he insulted my mother, I blew his brains out. And the officer is there and puts him under arrest, has no recorder. That's not allowed to go into testimony. An excited utterance, a statement of confession made, we lose that. He gets to the court, he denies saying it, says he never said it, they have no proof. We're then in adult big court, and we're going to lose that.
Can you reiterate that scenario again?
Yes, ma'am. An officer pulls up, and there's a dead gentleman laying there with a bullet in the back of his head, and the young man who is 15 says he insulted my mother and I blew his brains out, and I'm happy I killed him. The officer has no recording. The officer's just driving around, sees a guy laying on the ground, gets out. That's not going to be admissible at any stage, even though it is admissible under all current law, because it's an excited utterance. It's a plea against interest. We're changing 500 years of law. Yes, Representative, am I overlooking you, Representative Lamar? Okay, Representative Griffey.
Mr. Chairman, I was looking over the language of it. It's my understanding that this applies to in-custody interrogations at a law enforcement facility. So in your scenario, if they made excited utterance at the scene or something like that, it would be admissible. I do have some concerns that you raised. I assumed it was juvenile court proceedings because we were talking about delinquent or unruly. A lot of times juvenile cases, if it's serious enough, can get referred and prosecuted in circuit court and prosecuted as an adult. So I do have some concerns about that. What I would suggest, and this bill makes sense. I see what we're trying to get, but I agree with the chairman and some of the others on the committee that we need to be careful how we word this so we don't create problems for ourselves. If maybe we could consider that, I just throw that out as a suggestion. Thank you, Mr. Chairman. Thank you, sponsor, for bringing it. I agree with your intent on this, though.
Representative Lamar, if I'm having complete agreement with the members of your party down there, who I think make excellent sense. I think this really needs to be looked at. If you would consider rolling it a week and taking a look at this, because I know what you're trying to do. It makes perfect sense, and I agree with it. But we can't allow one good thing over here to really bring some disastrous consequences on the other. Juvenile cases often start as juvenile cases and then end up as criminal cases. I had many a murder case where the person was under the age of 18. But it's up to you. You can. I'm certainly not suggesting that in any way. I'm just saying I think he made a lot of sense. Oh, Representative Lamar, I'm sorry, I didn't recognize you.
It's okay. It's okay. I will say, I think some of the concerns are valid, but I think they're getting to things that my bill doesn't address. However, I am totally okay with rolling a week to add additional language to add clarity to it, to give it same intent, and then to have some one-on-one conversations with you all about this bill. But if it's okay with the committee, I'll roll it a week and come back and see you next week.
Is there any objection? I think that's wise, and I appreciate you doing that. Roll 1 week.
No problem. Thank you.
Let's get back. I think we're back to item 5 now, if Melinda's counting right, and I'm sure she is. Representative Gillespie.
Second.
We have a motion and a second on House Bill 0662 by Representative Gillespie.
Thank you, Mr. Chairman.
Representative, you're recognized.
Thank you, Mr. Chairman. Let's try this again here.
Is this your third bill? Just a little humor, sorry.
So what this bill addresses is the Tennessee Community Service Agency Board. Right now, it is, their annual plan is reviewed and approved by the Comptroller's Office, and this would allow them, it's a bit of a conflict of interest right now, and this would allow the Comptroller's Office to not both review the bill and approve, or to not approve and review. So it would place part of that burden to the Department of F&A, and this is a comptroller bill. They are for it, and I welcome any questions.
All right, any questions of the sponsor? Seeing none, hearing the call. All in favor, say aye. Any opposed, say no. Bill passes to counter and rules. Good job. Okay, Vice Chairman Jernigan, I want to turn the chair over to you. I got a couple of little matters I need to handle for you.
Thank you, Chairman. Members, we're going to be discussing item number 8, House Resolution 21 by Chairman Carter. Got a motion and a second. The bill's properly before us. Chairman Carter, you recognized.
This is our yearly action that we take yearly, as I just said, to ratify and approve the amendments and the revisions of the Tennessee Rules of Civil Procedure as they're promulgated by the court. The court promulgates them, we must approve them. That's what we're doing now. I'd ask for your support.
I have a Representative Clemens, you recognized.
Thank you, Mr. Vice Chairman. I simply was going to ask a question in jest. As Representative Garrett pointed out, some of us have jobs outside of this building, and I would really like to advocate for eliminating Rule 56 while we're at it, just while we're on the record here. Thank you, Mr. Chairman.
I understand.
Are there any more questions from members, like real questions? Seeing none, we're ready to vote on House Resolution 21, sending to calendar and rules. All those in favor say aye. Aye. Those opposed? Ayes have it. Let's see, item number 9, House Resolution 22.
This is House.
Got a first and a second, properly before us. Chairman Carter, you recognize.
Thank you. This is the House Joint Resolution to ratify and approve the amendments and the rules. These are the revisions and the rules that have been made by the Supreme Court, amendments to the appellate rules, much like what we've just done to the Civil Rules of Civil Procedure. They amend them, we approve it, we must do it every year, and that's what I'm asking you to support.
Members, any questions? Questions been called. Without objection, we're going to vote on House Resolution 22 to also go to calendar and rules. Those in favor say aye. Aye. Those opposed? Ayes have it. And I'll turn the gavel back over to Chairman Carter.
Thank you, committee. Any other questions or comments? I really appreciate Representative Lamar taking that bill and taking a look at it. That's one of those things that just makes perfect sense until you start thinking about some things you've been through, and then, my goodness, that could get in a headache and hurt some kids really quickly. That's a little bit scary. So anyway, let's make sure it's better to go slow and than to get in a hurry. So I appreciate Representative Lamar doing that and Representative Clemens suggesting it. Any other questions or comments? All right, do I hear a motion? We adjourn. Adjourn.